Now back to the show. This is The Law Show on CL 650.
Welcome back to the program. Nice to have you along with us this morning. Our subject is immigration law. Our guests are Gordon Maynard and Rudy Kisher from Maynard, Kisher, Stojkovic, immigration lawyers here in Vancouver. Gordon was talking, we wanted to talk during the break. You mentioned we were talking about these temporary one-time permits that a border agent or a representative of the government can give you abroad if there are some issues regarding your admissibility. We're talking about who can get into Canada and who can get tossed out on this episode of The Law Show. And Gordon, you wanted to come back to this matter of discretion because Rudy was talking about that border agent who may question you as to your admissibility, may identify an inadmissibility issue, but who still has the discretion to issue you a temporary permit to come in Canada and take it from there. And it's that discretion, Gordon, that you wanted to speak to.
Absolutely. The Canadian Bar Association has long said that discretion is the oil that keeps the machinery of enforcement running smoothly.
Okay.
And that's a very important concept. Very important concept. Our laws regarding inadmissibility are very strict, and they cast a very broad net. They capture a lot of people. And if you enforce those laws strictly, you are going to be keeping a lot of people out of Canada where there really isn't justification. If you had thought about it and come to a reasonable conclusion, you would say this is a case where we can allow that person in. Now, that exercise of discretion is important, and it always has to be preserved.
Mm-hmm.
We see it in different points in the enforcement process. And one of the most important ones is the use of tribunals to review removal orders against permanent residents. That's a place where discretion can occur. And that's a place where we want to see that discretion preserved. It's a very important role.
Okay.
We must always be cautious against any whittling down of that exercise of discretion. Hard and fast laws do not serve the community well.
Have changes to the new Immigration Act, as Gordon indicates, Rudy, in addition to perhaps adversely affecting the latitude of discretion, have they also, in many cases, eliminated discretion altogether on some files and some particular categories?
Oh, there's in a lot of categories. An example, that we haven't talked about yet is, for example, illegal work. So somebody is in violation of their work permit. They're here already in Canada,
right?
And their work permit's good for 6 months. They're busy working. They work past the 6 months. All of a sudden, they've worked for 7 months, and they realize, I better stop working. I've got to apply for a work permit. They go and do that. The immigration officer says, well, when did you work? The person explains, I worked for 7 months, and he's like, well, that's, you worked for 4 weeks past the validity of your work permit. Sorry, I can't give you a new work permit for 6 months.
Oh.
So the person has to leave, has to stop work, cannot work for 6 months. Whereas under the old act, there was no provision on that. Now, an officer always has a right not to give a work permit, right? That's always a possibility to say, well, you violated last time. I'm not going to give you a new work permit. So they had that discretion. The government's now taken away that discretion so a simple sort of administrative error that happens to people where they sort of forget to renew things and they're working away, the officer no longer has a discretion. Sorry, that's the rules. And same thing with studying. So you can imagine, a young student here, 19 years old, going to university, busy, having a young life.
And we have thousands of them here.
And they violate and they study beyond the validity of their study permit. The Act says if you've studied illegally, we cannot have you give you a new study permit for another 6 months. You can't study for 6 months. Taking away that discretion to me has just made it, we're really punishing people for really minor things that are oversights that happen to people every day. And I don't think it's serving us well.
I'd like to give another example.
Sure, go ahead. Yeah, please.
This one's a much more, I think, serious side of things. And that is for criminal inadmissibility. When it's being enacted against permanent residents in Canada. These are immigrants in Canada, people who typically come here as children, lived here for decades.
Mm-hmm.
And as they grow into adulthood, for various reasons, some of them do run afoul of the law, and they get a deportation order for criminality. Because they're permanent residents, because they've been in Canada with status all these years, they have traditionally had a right of review of that removal order, the criminal inadmissibility removal order. And at that review, they look at things like who you are, how long you've been here, what's the nature of your criminality, what's the likelihood of rehabilitation. Right. They make a decision in a tribunal as to whether or not they should actually enforce that removal order against you. And it's a tribunal hearing that's attended by the government and by the individual concerned. There was a decision made 10 years ago that they wanted to draw a line and take away access to that review. And the government of the day put in a 2-year rule that said if you got sentenced to a 2-year conviction in Canada, you had no right of appeal. Okay, it was a hard and fast rule.
Okay.
The CBA spoke against that. We thought a hard and fast. We never like hard and fast rules.
Right.
There are going to be cases where it makes sense. There's going to be cases where it's not.
So any sentence 2 years or longer, and you were out of the game.
Yes, once you get your removal order, there's no
okay.
appeal to the appeal division.
Okay.
There is a possibility that the minister can intervene, but that's quite unlikely. This government changed that rule. We didn't like the 2-year rule. This government changed the rule to a 6-month rule. So now, if you get a 6-month sentence, you have no appeal against it.
I think it's important to understand a 2-year sentence is a pretty serious sentence. That's federal time,
Right,
right? At 2 years, you're going to the federal. You're
That's
not
right.
going to the local, provincial authorities. 6 months is something that's handed out in a lot of cases. While it's a serious conviction, it is not a 2-year sentence. Judges hand out 6 months, and there are now, what the Conservative government has done is change the criminal code also, taking away judges' discretion. That for a lot of offenses, there's a mandatory sentence.
Right. The
of
minimum
more than
sentence
6
stuff.
months.
Right, sure.
And keep in mind, we're not saying that these people should be allowed to stay in Canada.
Right.
We're just saying that they should have access to the review. Let the review decide whether or not it's appropriate that they be removed.
So in addition to a diminishment of discretionary powers for immigration officials, I sense that there's an equal amount of diminishment of the whole appeal review process.
Yes.
Is it completely gone, or are there still occasions where individuals and their lawyers can appeal?
There's still appeals. But, year by year, you feel it getting constricted, whether by taking away access to the appeal division or just by the overall tone of a law and order agenda, let's say.
I think it's important to look at the history of this, too, because criminal inadmissibility, up until 1976, so when we had predominantly European immigration coming to Canada,
Right, sure.
up until the 1976 Act, there was, there were very few occasions where you could be deported from Canada.
Mm-hmm.
So if you were a permanent resident, unless you murdered somebody, sexually assaulted somebody, committed criminal treason, it was unlikely that you would ever get deported. You would serve your time in Canada, be
Right.
sentenced in Canada. If they still had a capital sentence, you would suffer that. But you were only deported for very, very serious crimes. You were seen basically as one of our own. That's when we had predominantly European immigration.
Correct.
In the 1970s, our immigration policy changed quite a bit, that we started getting immigration from non-European countries.
Mm-hmm.
A lot from the Caribbean, a lot from Asia. And with that, we have progressively seen the inadmissibility requirements getting tougher and tougher on permanent residents, people that we consider almost Canadians,
Sure.
almost Canadian citizens.
Who've been here for a while and so on.
Yeah, and we've seen now with this government, even the discretion getting taken away.
So what is the object of the exercise, do you figure, Gordon? Is because we're still, our immigration numbers are basically the same. They've been the same for decades. We allow approximately 250,000 people to come into Canada every year. And so is this an attempt in a long-term planning sense to reduce our quota on an annual basis for specific reasons? Why these rather harsh sounding changes?
Because some governments have an agenda of promoting law and order issues. And so you make the laws tougher. You create the sense that there's abuse going on. You create the sense that people are taking advantage of an appeal system. And it's not correct, but it's a misconception that's put out there, and then you politically react to it, and it's a political issue.
It's a horrible case which Jason Kenney used to talk about. There was a situation in Toronto where a man who had committed some horrible crimes had been given a deportation order. So the system had worked.
Yeah.
They'd said, you've got to leave Canada, you're no longer allowed in here. Unfortunately, the Canadian government, CIC, did not act on removing him. They lost his file, basically, and didn't remove him. And so what happened is, unfortunately, a horrible incident, he ended up killing a police officer. The police association, the Toronto Police Association, sued Citizenship and Immigration for not having removed him. And actually, they settled out of court. So they gave a settlement to the police association for not having removed that guy. Jason Kenney held up and said, this is why we need to change the law. Because this person wasn't removed. Well, we had a removal order to kick him out.
That's right.
The appeal division did its job in that case.
So the only place the ball got dropped was the removal department didn't follow through, put the guy on a plane and get him out of
He
here.
had a review. We looked at him. How long has he been in Canada? What are his connections? What horrible crimes has he done? It's too much. You're out of here. We had that process.
So because a staffer in that department drops the ball, the minister of the department decides to change the law?
I think he does it maybe to pander to his to his base and uses that incident, but unfortunately, I think mischaracterizes the facts horribly.
Yeah, absolutely. Look, I've dealt with the appeal division. We're talking here about the tribunal. We're talking about is the appeal division of the Immigration and Refugee Board.
Okay, are these judges?
No, they're laypersons. They're appointed through a government process.
Okay.
But their job, they have jurisdiction in certain cases, usually involving permanent residents in Canada. So if you're a permanent resident or a citizen and you've sponsored a parent and the parent's turned down for any reason, you can appeal that to the appeal division, and they will review that refusal and see if there's any humanitarian and compassionate grounds to justify your parents coming.
Okay, right.
If you are a permanent resident and you're ordered deported, say on criminal grounds, you used to have a right of appeal to have that reviewed,
yes,
to see whether or not in all the circumstances you should be deported. In some cases they would say yes, in some cases they would say no. I've dealt in front of that tribunal for 25 years. And what I like about it is it's an opportunity for common sense to prevail. It's an opportunity for everybody to put their cards on the table. The government is there, they put forward their evidence, the individual is there, they put forward their case, a person listens to the arguments, makes a reasoned decision, and comes up with a common sense decision. And sometimes common sense says, you're gone.
Mm-hmm.
And sometimes it says, we're going to give you a chance. We're going to let you stay here for another 5 years. And you show us that you are worth keeping. Because if you screw up, you're gone.
Right.
Okay. But that's a good way of dealing with the system.
It allows for a case by case.
Because these are questions that should be asked, but they aren't asked in the process until you get to that appeal. And now, when you take that away, now you don't have common sense decisions.
Right. Need to take another break, but just before we do, there is perhaps a really wild and crazy popular myth, but I just want to ask you about this, and I may have in the past. It deals with the removal department. There is this perhaps mistaken notion across Canada that we have in our midst thousands of people who are unwelcome, who have been ordered removed, who have vanished into thin air and have never been deported from Canada. Is that true, or is that popular urban myth?
I think the size of the problem has to be taken in perspective. So in Canada, the largest number I've ever heard of people that should be removed that are illegal immigrants still remaining in Canada, the largest number I've ever heard is about 100,000. So we're what are we, 32 million people, maybe a little bit more. The United States, with a population of close to 320, 340 million people, they have 10 million.
Mm-hmm.
They have 1/3 of Canada living in the United States illegally.
Right.
So our problem really in terms of illegal immigrants, it's a problem, it's an issue. Those people should be removed. They've been asked to leave, but really it's not the massive problem that sometimes is portrayed, because I think we suffer a lot from, we view a lot of American media and we think, well, it's the same up here.
Well, we do.
We don't have a porous border with Mexico. We don't have that issue.
The other part is that we don't keep track of when we how people leave Canada. So people who are given removal orders,
right.
Some of them are actually deported, and we have a record of that.
Right,
because
sure.
They're picked up and taken out.
Mm-hmm.
But others, we don't know where they went. All right? And so if you add up all the numbers of the we don't knows, yeah, it looks like a big number. But many, many, many of them have left.
Right.
How many of those are actually staying in Canada and living underground? Which is a hard thing to do. It's hard to do.
It's much harder in Canada, because in Canada, we won't give you a driver's record if you're not a legal immigrant, if you don't have some documentation. We won't give you MSP coverage. We won't take your tax money. In the United States, they do. They give out driver's records to illegal immigrants. They allow them to get health care coverage. They allow their kids to go to school. We draw a very hard line with that, and I think it makes for a system that discourages illegal immigration to stay.
We're talking about the Canadian, that would be our immigration system, with a couple of Vancouver immigration lawyers, Gordon Maynard and Rudy Kisher from Maynard Kisher Stojcevic, are with us and online. Check them out while we take a quick break here. It's vancouverlaw.ca, and learn a lot more about our guests and their firm while we do this bit of business.
There's more of the show still ahead. This is The Law Show on CL 650.